But I just wanted to ask, you were saying that you said that you have 350 members, mostly accountants and solicitors. Can I ask, and you're dealing with people who are in debt, can I ask, how do you determine, what I'm trying to find out is, what figure, or how do you determine the figure that you're going to get paid for your service, and who pays you?
Well, as Bill said, our membership is made of solicitors and accountants, and principally our work would actually be corporate work. There would be some solicitors who would do personal bankruptcy work, but it would be a relatively small number. And generally, in terms of the work we do on the corporate side, we're paid out of, if it's a formal process of liquidation or receivership, we're paid out of the assets such as they are. So we wouldn't have a great deal of experience dealing on the personal side.
Yeah, I think things would. Yes?
Yes, we don't get paid at all, unfortunately. So that's our position. Is we actually we have a small technical problem.
We don't get paid.
So no, but I mean, my understanding of the way it works in the UK is that the Personal Insolvency Trustees are paid from the deal. So if there's a deal done, that it involves a payment to the
and there is
trustees.
a very
You don't get paid for the work you do.
And there's a very important issue in relation to that, Deputy Ferris, is that if I'm in a borrower and I'm in difficulty, as this legislation is currently framed, I have to appoint an insolvency trustee. There's no understanding clearly at this moment in time for that borrower as to whom and when and how that person gets paid. Is it expected that I pay the insolvency trustee up front? Is it as part of the deal that's ever done? If one is done with the creditor, do I pay the insolvency trustee only to find out that the veto is exercised at 75% of the secured debt and bang, I've paid some money for something I don't get? So it's very, very clear that's a disincentive for a borrower to engage, and most of these people may not have those funds, and this is back down to regulation ensuring that this is clearly done. And the Competition Authority may need to get involved to ensure that, so what is anti-competitive practices? You cap the cost, end of story, that's all it can be for those borrowers.
So coming back to the legislation now, please.
Sorry, Chairman, can I just say thank you for that answer and to congratulate you for that, and I'll probably send you a list of about 5 clients I have.
That's right. Let's not be totally... Who's next? Sorry, Mr. Holohan.
I mentioned in my main remarks there's a huge amount of pro bono work done. The reality is that there's a cross-subsidisation between clients who pay, not necessarily banks, but those who pay for legal and accountancy services, which allows for that pro bono. But if you could be very busy all day doing pro bono work, but unless you have some private income, or Bill Gates is bankrolling you, you won't survive.
Thank you very much. Senator Batchik, you have a question.
Thank you, Chair. 2 brief focused questions, if that's okay. And just to welcome everyone. The first is a question for Mr. Holohan, which just to follow up on on your point earlier that there were certain companies or groups organising a UK history for individuals so they could avail of the bankruptcy tourism Deputy Kenny described. I just wonder, have there been any prosecutions for fraud arising out of that? Because it seems to me that's an instance of...
Not that I'm aware of.